This afternoon's case is Zhang Li and Sherry McFarland versus Evergreen Hospital Medical Center and others. I have Mr. White opening for 8 minutes. Response will be by Ms. Heidelberg for 20 minutes, and Mr. White has reserved 12 minutes for rebuttal. Counsel.
May it please the Court, John White on behalf of King County Public Hospital District Number 2. Washington treats public and private employment differently. This case illustrates two of those differences. First, Washington authorizes governmental employers to vary from generally applicable wage and hour rules in their collective bargaining agreements. Second, Washington's Public Employee Collective Bargaining Act expresses Washington's strong public policy preference that public employment disputes be resolved through grievance and arbitration, not litigation. The single meal period under the hospital district's collective bargaining agreement with its nurses varies from the general rule. Impossibility of compliance is the clearest evidence that the contract provision varies from the applicable regulation. Ms. McFarland's late meal period claim raised in the Second Amended complaint involves the collective bargaining agreement's express terms. The agreement's grievance and arbitration provisions are mandatory.
Can I take a step back from that? I certainly agree with you that there's a public policy in favor of arbitration, but that applies when two private parties together have negotiated an arbitration clause, and the public policy is to enforce that arbitration clause. Where in this contract is there a clause that gives the employer the right to compel arbitration?
The contract requires, Justice McLeod, that there be a grievance filed if there is a challenge to an express term. We're seeking to enforce the express requirement that a grievance be filed and then subjected to the grievance and arbitration provisions of the agreement. The decision on whether to arbitrate—
I thought it was a motion to compel arbitration.
Yes, but as explained and as detailed, we were seeking, our point with the courts has been that the contract requires that grievances shall be filed. Now, ultimately, the decision on whether to advance a grievance to arbitration rests with the union, the exclusive bargaining representative of the employees. We seek to enforce—
And not with the employer.
Not with the employer, but we are entitled to enforce the part of the agreement that requires adherence to grievance.
So why wasn't it a motion to compel grievance rather than a motion to compel arbitration?
I would suggest to you, Justice, that it's a nomenclature issue rather than the substance of the motion.
It's a really big difference in forum, whether you go through the process with your union of filing a grievance or whether you go to the arbitral forum with an arbitrator.
Well, the prerequisite to the arbitral forum is that the employee bring the grievance before the union and the employer.
Can I ask how you
Court, I'm
differentiate—
Cindy Heidelberg, counsel for plaintiffs Lee and McFarland in the certified class. This court should affirm the Court of Appeals and remand for this case to go to trial. The Court of Appeals correctly decided that Evergreen waived any right to compel arbitration that it had by zealously and vigorously litigating this case for 9 months before moving to compel.
So how would you raise that, I guess, affirmative defense as it's characterized? Must it come up through a motion early on in the proceedings to not face a waiver argument, or as in this case, can it be listed as an affirmative defense in the answer and be subject to a different analysis? I just don't know what happens to certain affirmative defenses that normally would proceed
Yes.
if they're in an answer, but somehow in this case it doesn't.
So the answer here suggests that from the get-go, from Evergreen's answer to the initial complaint, Evergreen was aware that it had a possible defense of arbitration. But what is really important here is then what happened afterwards. And what happened is that Evergreen, as the Court of Appeals said, acted for 9 months of litigation inconsistently with that right to compel litigation and passed up these—
I understand the procedure here, and I understand the concept of waiver. I'm trying to understand the relationship between pleading it as an affirmative defense and how that would flesh out in the course of the normal proceedings, as opposed to having an affirmative defense waived by action.
Okay,
And
yes.
the interrelationship between the two. And maybe it's just a confusion on my part conceptually, but
Evergreen has raised an argument that it had to plead this as an affirmative defense to have it not be waived, and that's not correct. If Evergreen believed there existed facts to support an affirmative defense, as it needs to do under CR 11, then it was obligated early on in the case to actually then move forward to compel arbitration on that defense. And if it did not believe at the time that it had that affirmative defense, it had the ability at the time at which it had facts sufficient to believe there was an affirmative defense to raise it at that time. I hope that clears it up. So again, Evergreen for 10 months acted inconsistently with any right to compel arbitration, and it passed up obvious opportunities to compel arbitration. It moved to dismiss Ms. Lee's claims for injunctive relief and for standing to represent the class, and it never said that those claims were arbitrable. During that exchange, plaintiff also very clearly to the trial court in the pleadings and the hearing said, we are not bringing a claim for injunctive relief, and that never changed in the second amended complaint, that there was never a claim for prospective injunctive relief raised.
Was there a difference between a claim about missed versus late meal or rest breaks?
No, there was not. So from the very beginning complaint, in each iteration of the complaint, the first one, the first amended, and the second, there has always been a late meal break claim. That's at CP3, Clerk's Papers 15 and Clerk's Papers 437. You'll see that the way the class definition is defined, there is a claim for late meal breaks. So if Evergreen believed that a late meal break claim implicated the collective bargaining agreement, it needed to raise that from the get-go, and it did not do that. Instead, as the Court of Appeals found, it chose consciously to litigate. It opposed class certification. It never said, this needs to be arbitrated, Your Honor. It asked the court to send out its version of class notice and never said, to the class, these claims need to be arbitrated. When plaintiff, after Ms. McFarland's deposition was taken, at that time she was still an absent class member, when plaintiffs moved to continue the trial date and said, we will be adding Ms. McFarland as a class member, Evergreen responded and opposed the motion to continue the trial and said, Your Honor, the inclusion of Ms. McFarland as a class member, as a representative plaintiff, changes nothing, and we are entitled to a trial on the merits of this case. Evergreen passed up all of these opportunities. Evergreen, the standard of review here is de novo, but there is plenty of case law in which the courts recognize that the trial court is particularly well suited to engage in this waiver analysis because the trial court is the person whom all of this litigation has taken place. And Judge Schaefer, the trial court, noted in her hearing, made a finding in the hearing on the motion to compel arbitration that what she saw before her was this long line of zealous litigation without any attempt to compel litigation. May I close, Your Honor?
Briefly.
Yes. The court doesn't need to look past waiver to affirm, but if it decides to look past waiver, it should find that these claims are not arbitrable. As I said, Evergreen is asking this court to rewrite the terms of the CBA to say something it wants it to say, but it does not expressly say, and the place for Evergreen to do that is at the bargaining table with WSNA. This court should affirm the Court of Appeals and remand for trial.
Thank you, Ms. Hyde.
Thank you.